Hi everyone. Can you hear me?
Ma'am.
Yes, ma'am.
Yes, ma'am.
Okay.
Yes, ma'am.
Okay. How was the week for everyone? Was it good or just the same?
It's the same, ma'am.
Okay, never mind. I just heard on news that we are getting a COVID vaccine very soon. Is that a true or it's just a speculation that's been going around?
Yeah,
No, it
it's
is
an
true.
about the same thing, and apparently the prices will be feasible for everyone. So it's going to be a little lesser than 220 rupees apparently.
Okay, but is it that the news is real? Because we have been hearing this news of COVID vaccine for a very long time
Ma'am,
now.
no, ma'am, it is real.
Okay.
It is
So it's
real.
just hopeful. When
I
is it
think
coming?
so. It is fixed on August 15.
Yeah.
Oh, okay. So August 15 is for like overall, because they said that in India it will be available later, not like first it will be available to US and other countries which have been suffered more.
No, only in India.
Oh, okay. Great then. Just kind of hopeful. Okay, let's get started with Article 19 again, because in the last lecture we only covered 19(1)(a). Right? Here we covered freedom of speech and expression. You can see my board, right?
Yes, ma'am.
Okay. So today we'll see B, C, D, E, F, and G. Okay. So what is B now? B is freedom to form an assembly. Okay. Then C we have freedom of association. Then D we have freedom of movement. E we have freedom of residence. Then F is property. And G is trade and occupation. Occupation, profession. Okay. So these six freedoms are called as golden freedoms. Okay. And it is available only to citizens of this country. Okay. So these all six golden freedoms. Now why I am saying six? 1, 2, 3, 4, 5, 6. Okay? Because F has been taken out. Earlier, when the constitution was framed, freedom to have property. Okay? Freedom to property was a fundamental right. But later on, it was taken out. And now F is no more there. Okay? And that's why we only have 6 freedoms. Now, right to property is not a fundamental right, but it is a mere constitutional right. Okay, so it doesn't come under fundamental rights now, and that's why under Article 32 or under Article 226, you cannot reach out to higher courts for anything that has been covered under right to property. Okay, hence we only have 6 freedoms, which is called as 6 golden freedoms in Indian Constitution. So what are those 6 golden freedoms? Freedom of speech and expression, freedom to form an assembly, freedom to form association, freedom of movement, freedom of residence, and then freedom of profession, trade, and occupation. Okay?
Ma'am?
Yeah.
Ma'am, then where was property placed?
It is in constitution only, but it is just a constitutional right. Now it has been taken out from the purview of fundamental. Okay?
Yeah.
So let's get started. 1A, we have covered it in detail. Okay, so today we will see assembly. Now, what is assembly? What is assembly? Anyone? Yeah?
Gathering in one place.
Yes, gathering at one place. So it could be any gathering, okay? It could be public meeting, it could be political gathering, it could be social gathering, it could be even the college gathering or any sort of gathering, okay? But here, this assembly speaks about gathering. It could be any gathering, as in I just said, right? So this kind of gathering should be two conditions it should fulfill. One is it should be a peaceful gathering, okay? And second, it should be without arms. Okay, so now assembly, what is, so if we are talking about assembly, in nowhere in Indian constitution it has been defined that what is assembly, how many people and all. It hasn't been described anywhere in the constitution. But because nowadays assembly is in very much talks, because after the CAA issue, people used to gather a lot on various things, even it happened in every state. And then what happened with that assembly? Then it was a peaceful assembly because we were fulfilling the peaceful as well as without arms. Then where it went wrong, right? So unlawful assembly, then obviously, because here we are talking about a peaceful assembly. Now what is unlawful assembly and why it is important to know? Because as it's a hot issue, okay, so they might give you this as well as they might give you that, a comparison that in IPC we have this defined. Now what do we have in IPC is what is unlawful assembly. Okay. Okay. Now under this, what has been said that if there are 5 or more people, okay, and 5 or more people having one common object, which is not lawful object. Okay. So I will read out those 5 things for you and then you let me know if you have any doubt. Okay. So it reads as, this is from IPC. Don't get confused because we are talking about lawful assembly, which is a fundamental freedom. So we must know what is unlawful assembly. And out of all the laws, unlawful assembly has been defined and described properly in our substantive law, which is IPC, under section section 141. Okay, so under section 141, so section, you need not know section because now the pattern is easier. So just for the sake, if you can remember, it's all fair. It's, if not necessary. Okay, so what is unlawfulness assembly? An assembly of 5 or more people. Okay, so it is talking about 5 or more people. Okay, 5 or more people if the common object of the persons composing assembly is, first, to overawe by criminal force. To overawe by criminal force or show of criminal force against central government. Okay. Okay. So under 141 of IPC, if 5 or more persons who are forming an assembly, okay, and if their common object is to, first, there are 5 uncommon, like unlawful objects has been described here. First is to overawe or to show criminal force against now all the highest law making authorities. Okay, so we are talking about here parliament. Okay, so if it is parliament, because we are talking about all the authorities, so obviously state legislature will also come here. Okay, then central government, so obviously the state government will also fall here. Okay, and
Criminal forces section 350, right?
yes, criminal force is section 350 and force has been defined in 349. But here we are not talking about the normal force, we are talking about 350. Okay?
What is that 14 IPC?
What?
What is it before IPC?
What before IPC? This is 141 section
Oh,
of
141.
IPC. Yeah. Okay?
Ma'am, the board is not visible after state legislature. What do
Okay,
you
fine.
know that?
Yeah. So if you are showing any criminal force against parliament, against the state legislature or central government or state government, it is state government, and then I'll write it here, any public officer. Okay, so if you are showing criminal force against these authorities, then it will be considered that your common object is unlawful. Okay, because saying that okay we are against this law and you are assembling peacefully for that, that is fine. But if you are saying that you are using the criminal force, then it is punishable.
Ma'am,
Okay, you will be considered as this organization, this assembly will be considered as unlawful assembly. Yes.
criminal force in the sense going against them.
Yeah, showing something like see, actually this is not important for you guys because this is just CLAT level, but I am still giving you 141. But again, if you want to know 350, then again it's a detailed article and it will take some more time. So what you have to remember is criminal force is going or doing something and giving injuries, and that injury just not physical injury, but it could be mental injury, it could be trauma. So if you are doing that, or if you want to learn 350, everyone? Guys, I'm asking you question. Yes, no, no ma'am, or maybe later.
Yes, ma'am.
Anything. Okay, so let me read out the definition of 350. Okay, whoever. Now whoever again we know with the change of time. Okay, guys, let me do one thing. We'll go to our back normal rule that when I will ask you a can you go on mute, Harshit? People, can you go on mute, please? Okay, so 350 criminal force means whoever intentionally uses force to any person without that person's consent. Okay, so as simple as that, if I am using force against on you without your consent, okay, then in order to commit any offense, I wanted to commit any offense, that's why I'm putting that force, intending the use of such force to cause, knowing it to be likely, or by use of the force, he will cause injury, fear, and annoyance. Okay, so criminal force means, I remember it as IFA. So IFA means injury. Okay.
Ma'am, we can't really see that side of the board.
Sorry.
We can't see that side of the whiteboard. Yeah.
Now it's fine.
Yeah. Yes, ma'am.
Okay. So how do you remember criminal forces? when you are putting a force on another person, okay, without that person's consent. And why you are doing that? Because you wanted to cause injury that to person. And injury, then again, I just for your sake, if you can remember, it is given in section 44. So it says that any harm to these four elements. Now, what are this? I remember it as harm, which is 1, 2, 3, 4, 4 words here, and this 4 units again 4. So section 44. Okay. So harm to your body or to your mind. Okay. Then to your property, and R is what was R? B M R. R. I'm not getting R.
This is not relevant, right, for CLAT exam?
No, that's what. But someone asked me, so I was like, okay, let me give. If you can remember it, well and good. If you can't, doesn't make any sense. Like, you know, you don't have to get scared for that. So leave it there. I'll just tell you R, what is R for later. So we were saying that what is unlawful assembly. Okay. So if 5 or more people gathering with a common object to overawe or to show criminal force. Now we know what is criminal force. If you want to give injury, if you want to give fear, if you want to cause annoyance, if you are doing any of this, that is IFA, okay, then it will be considered as criminal force. Okay. So if you are using this, if you want to give injury, so you are doing something which is causing injury to our parliament or our state legislature, central government, state government, or public officer, or you are making them fear. So you are just, giving a fear to the police officer who's performing his duty, that if you will not do this, then, I will do this to you and all. So what you are doing, you are causing fear. And then if you are annoying that police officer, or if you are causing annoyance to any of these bodies, then it will be considered as, and that too 5 or more people should be there. If 5 or more people causing this thing, then it will be called as unlawful assembly. Okay. Then second is, if someone is performing their lawful duty and you are interrupting in that. Okay, so for example, now judge is under the duty to give fair judgment in any case, right? But what you are doing, you are making him fear, you are causing annoyance, and you're just gathering outside his house, okay, 5 or more people, and telling him that, your judgment should be in favor of us. So what you are doing is you are interrupting the course which is legal, but you are interrupting it. Okay, so that is second. Then if you are committing any mischief or criminal trespass, so sometimes what happens कि अगर एक इंसान किसी के घर में घुस जाता है, right, या किसी के land पे trespass कर लेता है, trespass as in that land doesn't belongs to you, but you are still interrupting into that land. You would have seen this hoardings, right? No criminal trespass, no trespassing, right? So it means that you are not allowed to come on this land. So when you are asking 5 more people to join you so that you can trespass that property, you can just go on that land, you can just go on that house, so that will be called as criminal trespass. Okay. So if you are using this 5 people's assembly to do criminal trespass or any mischief again is something ki 5 लोगों का group बैठा है, आप सीटी बजा रहे हो, कोई लड़की जा रही है, so that is mischief, creating mischief. So that time also your assembly will be called as unlawful assembly. Okay. Then to deprive any person of enjoyment of right, so these are only common things. So you cannot make any hurdle using your assembly for anyone's, if first of all it is against government, then any person's right. Okay, so you cannot interfere in any person's right if he has a right to water
or if he has the right on that particular land to enjoy, and you're not letting him enjoy on his own land, okay, just creating ki assembly कि आप सब लोग यहाँ से चले जाओ, and he's telling कि ये तो मेरी मतलब मेरा land है, how can you just make me go? But because that person has 5 other person with him, you obviously get scared, because he has 5 people and they can do anything and you are just alone there. So though it is your land, they made you compelled to leave that place, right? So it is nothing but criminal trespass on your own land. So if people are doing such unlawful activities, forming the group of 5 or more people whose common object is unlawful, that time it will be called as unlawful assembly. Okay. So this was unlawful assembly as per 141. You don't need to go in very much detail in this, because the point is you should understand what is lawful assembly and what is unlawful. So lawful assembly has been given in fundamental rights, which says that any assembly, it is not giving any picture of 5 or more, but it's saying that 2 conditions should be fulfilled. One is that assembly should be peaceful assembly, okay, and second is that assembly should be without arms. Okay, so 2 conditions only you have to remember. One is peaceful and second is without arms. Okay, clear? Now, why people form this kind of assemblies? Because obviously they have one common lawful object, and for which they want to gather, and they want to convey their thoughts, or maybe they are angry with something, and these people are like-minded people, so they form this assembly. Now, forming assembly is just not as easy as, okay, you are just going and having a gang of friends and sitting on the road. No, it doesn't mean that. So if you are for any political gathering or for any public meeting, you have to give an application to that police officer, whoever is the police station head. Okay, so if I am staying in Jayanagar, okay, so I have to write to the Jayanagar police station that this is the object of our rally, or this is the object of our public meeting, this is the object of our public gathering, and hence kindly give us permission. Okay, so once they give you permission, then only you are allowed to carry on any rally, any public meeting or anything. But if you haven't taken the permission, then again it makes the whole meeting illegal. Okay, not only that, but now see, Ganesh Utsav will start, and even for, if it is a public Ganpati, I'm not talking about when you take that Ganpati for your own house, that time you don't need any permission for sure. But if you want to make it as, this a particular Jayanagar ke liye, if you are getting that Ganpati and it will be a public event, then you have to take a permission from that police station that, at this address on this road we are going to make this public event, so we need permission. Okay, so there is this case
also, permission is important.
Yes, permission is required if it is if it's going to be a public event. If it is just your own house and few relatives and you're just 2 or 3 families, you're doing it as a family gathering, then you don't need that permission. Okay. So that was all about the assembly. Now there is one more case law where it was decided that it was Himmatlal versus Police Commissioner. Again, in this case only, first time the court said that right to hold public meetings or assembly on public street without police permission held as bad. Okay, so I have already discussed this point with you, that you have to take the police officer's permission, whoever is the station head or the police officer in charge, and if they say yes, then only you can go ahead. Otherwise, in this case, they clearly said that right to hold public meetings or assembly on public street without police permission is held as bad. Okay, then again, this is not an Like, this is not unconditional. Again, there are conditions on this, like we have seen in freedom of speech and expression. There are conditions that, it shouldn't be going against the friendly relationship. It shouldn't be going against the sovereignty and integrity of India. So even here, it says the same thing. It has the same restrictions, integrity, sovereignty, and in the public order. So if you are disturbing the public order, then again your public meeting will be held as unlawful. Okay, so that was about unlawful assembly. Now moving to association. Now, association is very much common, right? We have, like, even in school, we will be having one association. So if any gathering is getting conducted in our school or college, the first thing what will happen is you will be establishing some unions, some student union, some association, student association, or fundraising association, or something like that. Any body that you're organizing, okay, with lawful object, obviously, and lawful object. So here your object is to conduct the graduation program of your school or college. So if you are doing something like that, it will come under association. Okay, so this is freedom to form association. So you can say that, Lions Club, it is also one of the association. Students organization, ABVP is also an organization. Students organization, students association. Then trade unions, right? You would have heard about it. Trade unions, like management unions. So all these things will fall under the association, which is freedom to form association. But again, here also, the the purpose of forming this association should be a lawful object. Okay, it shouldn't be unlawful. And again, here one different thing is, what we say, the restriction is, one of the restriction is morality. Now, what do you think, why morality could have been given one of the ground here? Because what kind of assembly? Okay, so they are saying that just on the basis ki aap koi association, you can form any association. It doesn't mean that you will form an association of naked people. Okay, so that is against the morality, against the culture, and it will, disturb the public peace, public tranquility, because obviously our culture is not like that, you are just forming such kind of vulgar association. So again, the morality is one of the ground. So on this basis, if you have a lawful object for that particular association, be it students, be it trade union, be it any management association, that is valid, and you have that freedom under Article 19. Okay, so this is about assembly. Now, there is one big another, one group is there in India which cannot form association, and that is the armed forces, naval forces or air force. They cannot form any association, because obviously we are talking about our military force. And if our military force, if we give that power to military force, maybe it will start forming an organization, and one group will go against another group. So that way, our military cannot run. And that's why this case was, if you want to write it down, OK Nair versus Union of India, 1976. In this case, the court, that is Supreme Court, held that defense sector members cannot form association. So this is very important case law, and if any passage is coming on this, so you should be knowing that armed forces, that is defense sector, particularly defense sector members cannot form association. So freedom to form association is not available to defense members. Okay, am I clear?
Ma'am, you been asking us for the name of the cases and all?
No, they won't be, but just for your sake I'm saying. And even if they are citing, so everything will be given in your article only. right? But if any paragraph is coming on that basis, so you shouldn't be getting confused ki you don't know that whether it is available for military or not. So that's why this is important to know that it is not available for military members. Okay.
Yes, ma'am.
Yeah. And so there is this UAPA. UAPA is unlawful activities, Unlawful Activities Prevention Act.
Prevention Act. Yeah. 1967.
Okay. So this is one of the act which gives us, what is unlawful assembly and what will be the unlawful activities. So which are these unlawful activities which has been prevented?
1967.
So that is given in Unlawful Activities Prevention Act. Okay. And in this also, through this act also, several institutions were banned, several associations were banned. Why? Because though they formed an association which they have a right, but if they are regulating unlawful activities through those associations, then it is not lawful. Okay. And the Supreme Court can give orders to ban those organizations. It could be for some time, maybe temporary, or it could be permanent. So there are this organizations or associations which were banned, which was Bajrang Dal was one of the dal which was declared as under unlawful activities. Then Vishwa Hindu Parishad as well. Then Jannat-e-Islam-e-Hind. This is one Muslim organization. Even that was banned under UAPA, that is Unlawful Activities Prevention Act. Okay. So though we have this freedom of association and freedom of assembly, but whatever you are doing under that association or in that assembly, it shouldn't be unlawful activities. If they are unlawful activities, you will be regulated under, you will be punished under UAPA, that is Unlawful Activities Act 1957. Okay.
1967, right?
I have written it as 1957. So you just double check if it is 57 or 67. Okay.
Yeah, it is 67. It's written.
Okay. So then it is 67. Okay. So the case was again OK Nair versus Union of India, in which the Supreme Court held that defense members won't be having any right to form association. Okay. Then coming to freedom of movement. Freedom of movement. Now, what is movement? Everyone knows, right? That even though I'm a Maharashtrian, I can move to Karnataka, and then not only to Karnataka, any other state which I feel like going, right? So you have three basic rights under this. You can go to any other state or any place, okay, out of your state. You can enjoy that place, okay? So you have the right to enjoy by doing the movement to that particular, then you have right to reside. So if I'm liking that place, okay, I can reside there for maybe temporary. And then if I like that place so much that I wanted to settle down there, then I can even do that, okay? So that is right of settlement. So there is no restriction on these things when you have to move from one state to another. But we have already seen that under Schedule 6, there are several states under which we have discussed this, right? You need inner line permit to cross those states because of protecting that particular tribes or particular people from the acquisition or anything that is coming from outside, because they wanted to serve or they wanted to protect that particular community, particular tribe from getting bombarded
Excuse me,
by
ma'am.
these people. Yeah.
Like rallies and all are also known as movements only.
No, rallies will come
Like,
under
for fighting for Kaveri and all, the movement started, right? That is like legally, ma'am.
Which one? I'm not sure. Which one you're saying?
Okay, any example like for the Kaveri, in
For
Karnataka.
Kaveri, there you are
Yeah.
finding, there you are not moving only for water. Was it like only moving for water
No,
from
no.
one place to another?
No, but I'm just like an example I was just telling.
Okay. So see, if you are like, I'm not aware what you are actually talking, so I cannot give a exact explanation. Okay. But movement means, I'm just saying that for anything, for any job, or for any, if you got job to another place, or if you just want to travel to that place, or someone like you just wanted to see that state. So all these kinds of activities are regulated under freedom of movement. Okay. So no one can stop you from going from one state to another. So that is freedom, which was given with the intention of, you know, having that nationality feeling among yourself, ki we are one and we can go from one state to another, because basically we are Indians. So before states, what we hear is we are Indian. So that kind of nationality should be, you know, among us. That kind of brotherhood should be among us. That's why this movement of freedom of movement was given to us. Okay. And then freedom of settlement, that to reside, also comes along with this, but it is separately given. So after freedom of movement, there is freedom of residence. So as I said, that if you like that place a lot and you know that you are going to serve this Karnataka government for 5 years of your job, and then after 5 years you want to settle down in Karnataka, you being any, like being Maharashtrian or being Gujarati or being Rajasthani, you can still do that. And that is freedom of movement and freedom of residence. Okay. So no one will ask you, "Hey, you are Rajasthani, what are you doing in Karnataka?" Okay. That is not there. Why that is not there? Because we have freedom of movement and freedom of residence. Okay, which is our fundamental right. And you know that no one can touch your fundamental right, because you have access to Article 32 and Article 226. Okay. So am I clear till here? Yes.
Ma'am, can we reside or settle in that areas which we have to get special permit to enter?
No, we cannot. So because when we are, even for entering, when we need the permission, which was earlier in Kashmir also it was there, but now they have made it open, like after that new law, they have said that now you can also buy land in Kashmir, which was not there earlier. But now that has not been explicitly said, explicitly as in with letters, or openly has not been said like that. Okay. So still, if you want to, you cannot buy land. And if there are, like, if you want to, or there are some other complications which is involved, maybe you are a relative of that person who is already in Arunachal Pradesh, where you need inner line permit, or Manipur, where you need inner line permit. So that time, then again you have to make request, and then it depends whether what kind of resolution the court will be giving it to you. Okay. So only that time it will be. But then for normal people, or normal, like, citizens, this is the that you cannot go to these places which has been protected under Schedule 6 of Constitution.
The Northeast
Okay.
states, yeah.
Yes,
you,
that's it.
you mentioned about some articles. What is that one?
What articles?
The article you told under that it comes.
No, I said under Schedule 6, some states has been preserved.
Okay, yes. Before that you told something.
I don't remember.
Oh.
Article 32 or some Article 32.
Oh, I said that these are fundamental, and you can go to directly to Supreme Court under Article 32, and you can go to High Court under Article 226.
Yeah.
Okay, because we have been seeing this, that if any of your fundamental right get infringed, that is violated, then you can go to directly Supreme Court or High Court, because they are fundamental in nature. So this is also not an excuse, because this is your fundamental right. So even if any freedom of yours is getting violated, okay, out of the 6 golden freedoms, if anyone even getting violated, you have direct access to Supreme Court under 32 and 226. So you have direct access to High Court under 226. Okay. Yeah.
What if the Supreme Court is closed?
Sorry?
What if the Supreme Court is closed?
Supreme Court is known.
It's closed, ma'am. Now
Is closed. Okay. So see, we have like various, provisions for that. So like how the parliament will be sitting in winter session and monsoon session like that. So if at all one courtroom, like I got like so many notifications from High Court of Karnataka because I was there for a few years. So they sent me even the notification that this period, if not this court halls, then this one court hall will be in session. Then if that session, that court hall is not in session, others will be working. So they will be giving you guidelines. There will be notification that, you know, they cannot completely close it. And even if you have known that they are also conducting this online presentations and online, you can even stand for your court and give your defense over online as well, but few courts are all still in force. Okay, so there will be a proper notification which will be coming from that court that this court hall and this court hall will be open and this will be closed. So again, you have to keep an eye on those notifications, but it will never happen that everything has been, judiciary has been completely shut down. That will never happen. Okay.
Ma'am, but if I'm not wrong, due to the pandemic, for the past 3 months, the Supreme Court of India is closed. Like,
so it is not completely closed. That's what I'm saying. They are, you know, regulating and they are very much in force, but not all the court halls. So that's why, that's what I just explained, that, you know, they will be giving notification that this particular court hall is on and you can go there and, you know, just check your list. And then if your case is priority case, then you have to move an application that, you know, this shouldn't be prolonged and you want to present your case. And then again, you have to keep an eye on the notification.
Okay, ma'am. Thank you.
Okay. Yeah. Then so we are done with this. We are done with freedom of movement and reside. Then we have the freedom of trade, profession and occupation. Okay, so now why this has been given as a fundamental right? Why? Because we have a history where the son or daughter of king will be the future prince and princess, right? We had the tradition ki aapka agar ye kaam hai, matlab if Brahmins are there, Brahmins have to do this only, like puja part. If Kshatriyas are there, they and their generation should serve the military only, like they should be soldiers only, right? And the Shudras and these people should be only working for the upper caste people. So अगर स्वीपर का बच्चा है तो यू कैन सी दैट कि इनका जनरेशन से वही चल रहा है कि अगर स्वीपर है तो वो भी वही काम करेंगे, या तो फिर सोनार है तो सोनार का बच्चा सोनार ही होगा, he will also be doing the work of goldsmith only. So this should be stopped, okay, and everyone should get equal opportunity. And that's why we got this as a fundamental freedom ki now this will not be okay. Now even if a sweeper's son or if a maid's son want to be a doctor, he can pursue that education, okay? So he has the right to choose his freedom, irrespective of what the earlier generations were doing, okay? So that's why now we have that as a fundamental right. But now there will be certain regulations that state can do. So for example, state can pose ki, okay, if you want to be a lawyer, you can give LLB, but what conditions we have, you have to fulfill it. So if you want to go for national law colleges, you have to give CLAT, right? If you want to go for again practice, then you have to clear the bar council exam. So that is one. So this kind of restrictions can be put by the state, which you have to follow. But otherwise, you have no other restriction that what kind of occupation you want to go, what kind of trade you want to do, or what kind of profession you want to take. So there shouldn't be any barrier on this. And that's why we got this as a fundamental freedom to do trade, occupation, and choose our own profession. Am I clear now?
Ma'am, this is already there in Article 16, right? That is, there should be no discrimination of people on the basis of religion. That is on the basis of employment of jobs, like that.
No, this is here we are talking, that was public employment we were talking about. It was only for public employment. So we were talking about government jobs, yes, right? Here we are talking about profession. Here we are talking about trade. Here we are talking about the occupation, okay? So we are not talking about public employment here. It is totally different. So here we are just choosing of, though my family is full of doctors and we have been serving people, we have like big hospitals and we have been in doctor's profession, but now if that child wants to be a lawyer, he can do that because he has the freedom to choose his own profession. And that was public employment ki, state shouldn't be discriminating among anyone on the basis of race, caste, sex, place of birth or residence. So that was different and this is different. Understood?
Yes, ma'am. Yeah.
Yeah. Anyone has any other problem or issue or difficulty in understanding any point? No, right? Okay, let's move ahead and let's move to the very interesting article of Indian Constitution, which is Article 21. Okay, now Article 21 is also called as celebrity article. Why it is called as celebrity? हम किसको celebrity बोलते हैं जिसका नाम बहुत बार बार आता है, right? जैसे तैमूर है, Karina's son, right? So everywhere, even if he sneezes, even if he falls down, even if he sleeps, everywhere there will be like paparazzi behind him ki, aaj Taimur ne ye kiya, wo kiya. So that's how even this article is. Any case law, you just take any fundamental right. So if at all I am like, I am saying that inequality, like my freedom of speech and expression is getting violated. So if I don't have the right of speak only, then this is not life. Okay? If I don't have the freedom of form assembly, I cannot call it as life. That cannot be life. Mere animal existence cannot be termed as life. And that's why now it just started with the right when we have taken this. Okay? So we have taken it from USA. Okay? And this right reads as no person. Let me read it. No person, correct. Okay, so no person shall be deprived. No person shall be deprived of life and personal liberty.
The protection of life and personal liberty.
Yes. Okay, so life and personal liberty unless there is procedure established by law. Okay, so now we read it in Indian Constitution. It is no person shall be deprived of his life and personal liberty except under procedure established by law. Okay, but if you see the USA Constitution, it says that no person shall be deprived of life and personal liberty unless and except under the due process of law. Okay, so the whole confusion, okay, the whole Article 21 is based on procedure established by law. So what does it mean? So in simple words, that state cannot take anyone's life, okay, and personal liberty. So personal liberty means to move freely, to reside anywhere. So that is all comes under personal liberty, right? So if you are just going outside the road after 11 p.m. and you are getting arrested, you cannot call it as personal liberty, right? Liberty means liberty as in a freedom to move, right? So personal liberty under this, it is a very wide expression. So many things will come under this. Okay, so we will see it later. But as of now, you have to understand that this is one exclusive article in Indian Constitution which starts with negative lining, that is no person. Okay, no other fundamental right starts from no. But this is the one. And last, which starts from no person shall be deprived of his life and personal liberty except under procedure established by law. So, except under procedure established by law means if Parliament is making some law, okay, and that is putting restrictions on your life or your personal liberty, then you cannot question it. Okay, but if it is a procedure established by law And if that police officer is going against that procedure established by law, then obviously you will attract this article, that is Article 21. Okay. Now here we have to understand what is the difference between due procedure of law, which is given in USA, and what is the procedure established by law, which is in India. Okay. And this is important part of Article 21, that you should be knowing the difference between the two. Okay. Now, what is due procedure of law? And what is procedure established by law? Now, actually, the father of our constitution, that is B.R. Ambedkar, he wanted to put the same wordings as due procedure of law. Why? Because under due means what? Due means any procedure that the government is putting should be fair, okay, should be reasonable, and if it is not fair, if it is not reasonable, then we cannot call it as due procedure, okay, and just. So, fair, reasonable, and just. So any law. So here the control of USA, it has due procedure of law. So it is not only covering the executive, but it is also covering the legislature. Okay, legislature is a body which makes law, right? But in our constitution, we are talking only for the executive. Okay, so executive as in, we know that legislative and executive. Now legislature makes the law, right? And these people, which are called as executive, they are the ones who implement the law, right? So if legislature has made a law which is IPC, which is a substantive law. Now what is substantive and what is procedural? Does anyone know the difference? No? So substantive means only definitions are given there and the punishment are given. So the classic example will be IPC, okay, Indian Penal Code. So Indian Penal Code, if you read it, there will be only the definition of murder. Okay, for example, like murder is also one of the crime. So definition will be given, and for murder, how much punishment is there will be given. Okay, so now only that much is given, but how to do that? Like what is the procedure of arresting? What is the procedure of giving punishment? That is decided by the procedural law. Procedural law means the name itself says which gives the procedure. Okay, and in India we have, like if you see the criminal laws, we have criminal procedure law. It means there the procedure is given. So if you open CRPC, there it will be given ki if you see such person, how to lodge your complaint, how to lodge your FIR, FIR covers under which section, and how to go about the whole police case will be given in CRPC. Okay, that is a procedural law. So here under due process, the government, okay, the judiciary has power on substantive law as well as on the procedural law. Okay, but in India we have only, when you are saying procedure established by law, so this procedure is only applicable for the procedure, that is implementation, and you cannot question the legislature which makes the law. Okay, so if legislature is making any law, okay, you cannot question that law. So in India, the judiciary was not able to question the law which has been made by the parliament or the state legislature. Am I clear or it's confusing?
Ma'am, but the US can question the legislature.
US can question the legislature that do you have that right to make such law, And if you have right, and if you have made this law, is it on the principle of due? Due as in, is it just that you have prepared? Is it a just law? Is it a fair law? Is there a reasonableness behind this law? But we do not have that. Okay, you cannot question the legislature on the law. Okay, so you can only give the decision on the executive. So you have power only over the procedural laws, but not on the substantive law. So the law-making power, you cannot question the law-making power of Parliament, okay? But it was only until Menaka Gandhi case, okay? That's why Menaka Gandhi case is very, very important, because after Menaka Gandhi case, we have both now due procedure as well as the procedure established by law. Now we have to understand the case laws behind this, okay? But till before we proceed with the case laws, are you guys clear with the theoretical aspect of due process and procedure established by law? Or if not, it's really difficult to understand, so I can understand and I can re-explain you. Is there anyone who didn't understand, who want me to explain it again?
And then how can we amend the law, ma'am? Like if we don't have a right to question the legal this one.
Yes, so that's why I said now we had this only until Menaka Gandhi case. So Menaka Gandhi case happened in 1978. Okay, so before 1978, it was only the Parliament who was exclusively in making law, and we cannot make any amendments. Like judiciary has no right to say whether this law is okay or not. For example, A.K. Gopalan case is there, which is a fundamental or which is a landmark case. Now, what happens in A.K. Gopalan case is A.K. Gopalan got arrested. Now, he is a big figure in Kerala. Okay, he's a big leader, communist leader. And they arrest him and they keep him in the custody under the law which was Preventive Detention Act. Okay, so this law which was Preventive Detention under this law, so as I said, it's a law, it means it is an act which has been passed by Parliament. Okay, so when A.K. Gopalan goes to Supreme Court, this law under which I have been arrested, this is unlawful, this is not reasonable. Okay, so I don't think that you should be arresting me because this law is unlawful. Okay, so now when this reaches to Supreme Court said yes, but in India we do not have due procedure of law, so we cannot question the action of legislature, and you have been arrested under law, so this is a law. So this is a law which has been given by the legislature, so we do not have due procedure of a law in India. We only have procedure established by law, and this whole act has been covered under procedure established by law. So this is the procedure which has been given for arresting people. Okay, so that's why we cannot say that this is unconstitutional. We cannot question this act because it is made by the Parliament, the legislature. Okay, and then comes the Menaka Gandhi case, which overruled this. Overruled as in which changed the decision of Supreme Court. Reverse decision was given by the Supreme Court on the same facts. Like, so here the act which was in question was Passport Act. Okay, here it was Preventive Detention Act, and under Menaka Gandhi case it was Passport Act. Passport Act is 1967, and this case, Menaka Gandhi case, is 1978. You don't have to remember it, but just for general knowledge sake, Passport Act is 67 और ये case हुआ था 7-8. So you can just remember it that way. Okay, 6, 7, 7, 8. सो मेनका गांधी केस नाउ इसमें फैक्ट्स क्या हुआ था, ये इमरजेंसी के बाद में आई हुई केस है और अभी after the Congress has fallen down, now the Janata Party has come in power, and that's why this was one of the annoyance which was created by the Janata Party against the Congress. Okay, so here the facts of the case are very interesting. Ki Menka Gandhi passport which was issued to her under Passport Act, it was impounded, that is it was seized, and when she asked the reason that why you need my passport, why my passport is only been seized, they said that we are not liable to answer this to you because we are doing it in the interest of public. Okay, and she said then because it is my individual issue, because you are curbing my freedom of going from one country to another, okay, so you have to give me what is that reason where public interest is coming in the picture. Okay, so when asked this question by Menaka Gandhi, that time they said as that they are not liable, but Supreme Court said that when you are curbing any person's freedom, okay, so which is a fundamental freedom, so that time you cannot just do it under any arbitrary law. Okay, so here even not the whole Passport Act, but there was this section 10 if I'm not wrong. Okay, so section 10 was there under which it was given in the interest of public also they can do it. So then when this case came to the court, that time the Supreme Court said that nothing doing any law if it is passing the test of reasonableness. Okay, so test of reasonableness means the due process. Okay, because that law which is coming from legislature, it should be just, it should be fair, and it should be reasonable. So if it is not fulfilling any criteria of being just, being fair, or being reasonable, then we will strike down that law or that particular section which is against the personal freedoms or against the fundamental right of people. Okay, and that's why, just let me explain it and then you can pose your questions. Okay, and that's why they said that for the first time, and this was the case where the difference from due procedure and procedure established by law was dissolved, and now both are there. It means that now even judiciary has a right to give any decision on the any law. So now if the CAA is in question, right, so the parliament, because this is a law made by parliament, so now because of Menaka Gandhi case, the judiciary will be able to give any decision for or against for CAA. But if this case wouldn't have happened, then obviously we would have gone through the procedure established by law, which is only limited to the executive actions and not legislative. So we wouldn't have been able to challenge the constitutional validity of CAA in the judiciary, because obviously we only have powers for the executive action and not the legislative action. So now after this case, we have the legislative action also, we can speak about it if that legislative action is not fair, not reasonable, or not fair. So the test of reasonableness was given that it should be due. If parliament is also making any law, it should be due. So that is mandatory, that it must be fair, it must be reasonable, and it must be just. Okay, then only it will pass the criteria of constitutionality. Otherwise, the judiciary has a right to declare it as unconstitutional or null or void or invalid. Yes, now what is the question?
Ma'am, here we cannot apply intelligible differentia and reasonable nexus.
So yes, so that time, if at all, as because even government will be given a chance that why you have made this law. So here, that's why we are talking about the reasonableness, right? Reasonableness is also one of the factor. So that time, if the government is successful in telling that this is the test of reasonability, and that's why it is reasonable, it is just, and it is fair, and that is why this law. Now it will be on the court, the ball will be, in the judiciary's court, that whether they take it as reasonable or whether they feel it that the law is reasonable or not. Okay, so if they feel yes, it is reasonable, yes, the five countries they have chosen or the minority group they have chosen is right, then they might declare it as valid. If not,
So it is similar to reasonable nexus.
reasonable nexus only talks about that the object and the purpose should have a reasonable nexus, so intelligible differentia and one reasonable nexus. But this talks further, it talks that even if it talks about the legislative actions as well, that actions should also be fair and reasonable and just. So test, yes, it will be the burden will be on the government to prove the reasonable nexus, the differentia and everything, but ultimately it will be the judiciary's decision, which the judiciary will be giving whether they feel it reasonable or not, whether it is due process of law or not. Okay. So it shouldn't be just the procedure established by law, but that procedure established by law should be due procedure. Okay, so should be like this, whatever the procedure is there, it should be due. It means it should have just, fair and reasonableness within it. Otherwise, it will be declared as unconstitutional.
Ma'am, what does that executive body mainly do? It generates
They implement the actions. So they implement the actions. For example, see, we have IPC. So IPC is given by legislature. Now, who will execute it? The courts, the police officers, even the other bodies which has been given, like the CBI. Okay, so all these bodies are the executive bodies which will be using that same law and which will be following that same law. So these are the body of executives who implement that law, right?
Okay.
So the people implementing will come under the executive body, and the people who are framing, they will come under the legislative. Okay?
Okay.
Yeah. Any other question? If not, then we can just take a 5 minutes water break, okay? And we'll come again.
आखिर में
Are you guys back? Is everyone back? Okay. Okay, so now there's a big question which is here, which is, does right to life include right to death? What do you think? Do we have, because we have right to life, can we say that we have right to death as well?
Ma'am, right to death as in the right to kill yourself or something?
Yeah, right to kill yourself. So, for example, suicide. What is suicide? If you have to divide the word, the literal meaning, right? Su as in self, and side means killing. So when you are killing yourself, okay, so once you are died, that is out of question because you are dead, right? But if at all it was just an attempt, it means that you tried to suicide, but someone just saved you on time, or you got saved, though you tried to jump into the river, but someone just saved you and you were, you know, in the hospital, and you just get the news that, okay, whatever you have done was a crime under section 309 of IPC, which is attempt to suicide. Okay, so here so many people who have tried, you know, attempt to suicide, and which was punishable under 309, they say that if I have right to life, then obviously it means right to death also I have, because when you have right to speak under freedom of speech, you have right to remain silent as well. So when two contradictory rights are, you know, acceptable under freedom of speech and expression, then here also it is just the same. If we have right to life, then obviously we have right to death as well. Okay, so here we are particularly talking about section 309, which is attempt to suicide under 309 of IPC. Okay, and it is a punishable offense. Yes.
Does euthanasia come under it?
Yes. Okay, so we will talk about it, that what is it and why is right to death, right? But first you have to understand what is 309. Okay, so 309 says that whoever, so again, because of the new law, whoever means male, female, or any transgender, if they attempts to commit suicide or does any act in the same line, which is, you know, helping you to take your life. Any act, as in it could be anything, that you are buying a rope for just committing suicide with fan, or you are just buying poison or something like that. So any act which is doing, which is in the furtherance of this offense, then this is punishable in 309. Okay, now this punishment is not small. It is up to 1 year. So 1 year and with the fine. So just imagine that you already wanted to finish your life. It means you are mentally exhausted with something, and that's why you want to finish your life. And that's why you have taken such extreme step of taking your life, which is not easy, right? Only very bold or very frustrated people only can do it. So, so you are on the edge of frustration, and that's why you decided to take your life. But somehow, unfortunately for you and fortunately for others, you have been saved. And then police are coming to your house and arresting you, that, you know, what you did was a punishable offense, and now you have to stay in jail for 1 year, right? So this is not fair. And that's why the initial judgments, so there was this first case which was, there was one constable, police constable, and it so happens in his case that he met with a horrible accident. Now it even would have happened with you, right? That, you know, if you are in some you are in really, like, you know, jaldi hai kisi cheez ki aur aapka accident ho jata hai, right? So when you meet with an accident, or when you met with an accident, you get that whole picture in front of you, right? That, oh my God, what if this would have happened today? You know, all my plans, or what my mother would have done, what my father would have done, what would have happened to my boyfriend, girlfriend, or whatsoever, all the, you know, chaos will happen into your head, and you will really feel thankfully that, you know, I was saved. But if someone has taken there, have decided, okay, this is what I want to do, okay, and he's then that frustrated. So this person who was a police constable, he met with an accident, and that accident actually changed his life. He went into mental trauma.
And in that mental trauma, one day when he was, he buys the kerosene, he pours it onto himself, and when he was just, he just lights that matchstick, and he was about to burn himself or fire himself, that time someone just comes and saves him. Okay, and then this he was arrested under section 309, which is attempt to suicide. And in that the trial goes on, and in his trial he says that if I have right to life, why don't I have right to die? Because obviously it is one part and parcel of life, because this is how I wanted to live my life, by finishing myself. Then why is it not covering? Why it is punishable? Okay, so Supreme Court that time said, sorry, not Supreme Court, High Court, and this was Maharashtra bench, so it was Bombay High Court. So Bombay High Court said, yes, we are with you. What you are saying is true, because what we feel is, if a person, okay, if a person is under that mental trauma that he wants to end his life, so that time he doesn't need a prison. What he needs is care. What he needs is some mental rehabilitation center who will tell him that what he is trying to do is not fair. So in this case, punishing these people who are already frustrated with life, you are again throwing them into another prison of frustration. So obviously that feeling, that tendency of taking life will be even more, because they will be frustrated more कि इससे अच्छा तो मैं मर ही जाता, यहाँ पे तो नहीं आता जेल में, right? Because jail life is not that easy. You have to be like, away from your loved ones and all that. So this was the High Court decision, which was Bombay High Court. Then later comes P. Ratinam case. Okay, this is again a landmark case where Supreme Court also said that, yes, whatever Bombay High Court said, whatever Delhi High Court said in one of the other the Delhi High Court also said the same thing, that we have to struck down, we have to take out 309 from IPC, because it is unconstitutional. Because if you have right to life very much includes right to death as well. So if someone is trying to commit suicide, then you cannot be taking this as illegal, and you do not have to punish that person. So in this case they acquitted this person, acquitted as in they set them free ki no, you are not punishable, you can go home and do whatever you want. Okay, so these were the two cases. But then came the Jian Kaur case. So Jian Kaur is again a very fundamental case where Supreme Court, the citation is Jian Kaur versus State of Punjab. Okay, because various high courts were giving various decisions on 309, and that's why this time they wanted a firm decision from Supreme Court, because then it will be available, it will be a uniform code, right? Because it is coming from Supreme Court. So then Jian Kaur case, the Supreme Court said that the right to life does not include right to death, because this is the right which we have given, and it has no you cannot get withdrawn from, because it is a positive right. So we are not giving any negative right to you, because this is a democracy and we run on the basis of people. So if our citizens, if people are committing this kind of crime, obviously democracy cannot run. And that's why we need you, and we we need to care these people who are trying to commit suicide. And that's why then the parliament came up with a law as well, that Mental Health Care Act, right? So it came in 2018, and now that law says that, if it is proved that you are having acute mental stress, okay, so much mental stress, and in that mental stress, if you are committing a suicide, then 309 will not be applicable on you. Okay, so if other than mental stress, if there is some other reason, like if someone is behind you, or you want to some crime you want to hide, you don't want to give the real answer to the court, and that's why you are committing suicide, then it will not attract 309. But in my opinion, it's just the same. So if for other reason also you are committing suicide, it means you have mental trauma, right? Though it is legal, illegal, doesn't matter. Here the question is mental trauma, mental stress. right? So in this act, which was mental health care, they said that if at all it is proved that you have some mental, mental attention, so much mental pressure if you have, then we will not apply 309 on you. And on top of that, we will also provide care to you. We will also provide mental rehabilitation to you. So this is our duty, being the state, that if our citizens are going through mental trauma or mental stress which they cannot handle, then we should be there to care for them or to rehabilitate them. Okay, so this was Jian Kaur case. Jian Kaur case, but here they just said that right to life does not include right to death. Okay, so this was the standard version till Jian Kaur. Then comes the Aruna Shanba case. Now, what is Aruna Shanba case? Many of you would be knowing, but let me tell this if someone don't know. Do I need to explain, or you know already Aruna Shanba's case?
Ma'am, I don't know.
Okay, fine. So Aruna Shanbag was a nurse who was, working in the Bombay hospital. Okay, and she was really pretty, and she was that pretty that she got even engaged to the same hospital's doctor. So if doctor is marrying a nurse, obviously that nurse should be beautiful, right? Otherwise he would have married some other doctor. But here she was really pretty, and she was so helpful and nice. Like, she was having that reputation that she is one of the nicest nurse there. But one day, one unfortunate day, the sweeper of that hospital, he rapes her. Okay, but now that rape, because she was menstruating at that time, he doesn't do the vaginal penetration, but he does the anal penetration. Okay, and while doing the anal penetration, he used the dog chain around her neck, and because of that, her oxygen supply couldn't get to her brain, and she was in coma. So after that rape, she permanently went into the vegetative state, that is comatized. She was permanently went into coma. Okay, and there was no solution on that stage that time. But because, and after this incident, because that time, rape, and that to this kind of, her family also abandoned her. But this group of nurses, okay, they decided that yes, we will take care of her, and it is now Aruna is our responsibility. So they gave one bed to, because they are obviously working in the same hospital, so they strive that she should be getting one bed there, and every day one nurse will be taking care of her. And they were like such nice group of nurses who decided that they even started this culture that any girl, any new nurse who's coming to join the duty, first she has to meet Aruna, and then she has to start her duty. So it was going really well. But so though she was in permanent vegetative state, this nurses will clean her every day, and they used to maintain such cleanliness that though she was in vegetative state, otherwise people who are in vegetative state, they will stink, they will have lot of problems, they will have sores all over their body because they cannot move, right? So those sores were there on Aruna's body as well. If you see her picture, like how she was and how she became, it was really, it is like really painful, and just go through that case and you will get to know. So then what happened, one day one advocate visits that hospital, and that time the hospital authority was also of the opinion that why we are wasting one bed on this person who is in permanent vegetative state. So this lawyer, this over intelligent lawyer, I would say, she went to the court and she asked for the euthanasia for Aruna Shanbag for the first time, and that's why the whole euthanasia was very much in talk during that period, because she was in permanent vegetative state for 45 years. Okay, 45 years, you can imagine कि हमें 4 दिन भी घर में नहीं रहने होता है, 45 days का लॉकडाउन में ही हम लोग इतने परेशान हो गए. Just think of a person who is in permanent vegetative state for last 45 years. Okay, so she raised this issue that we should be giving euthanasia to Aruna because her condition is really bad.
But then this nurses again came to her rescue, saying that we are the ones who is serving her as family, and we don't have any objection of taking care of Aruna, and we are very happy with it. We will not allow any euthanasia on Aruna. Okay, and but then because the case was really strong, they said the decision started on talking about euthanasia. So the issue was in other case, which was social cause versus Union of India, that right to die with dignity should also be there. So dignity is very important for any individual, and if, for example, if Aruna is in the same state but there is no one to take care of Aruna, okay, then she would have been in a pathetic situation, where her body and her all over body, those burns are there, those sores are there, which are full of water, and no one is ready to take care. Then it would have been pathetic situation. So that time in Aruna Shanba's case and social cause case also, it was decided that people like the patients who are in permanent vegetative state, okay, so before going into that permanent vegetative state, if earlier only they are aware that okay, I have cancer and I might go into that permanent vegetative state, then if they have written earlier only their living will that if such thing happens with me, then euthanasia, passive euthanasia should be given to me, then only the passive euthanasia will be given to that person if he has living will. Okay, so read more about what is living will and what is active euthanasia. So active is something like this, that I am healthy, but just because I am frustrated, I want to end my life, and that should be granted under euthanasia. So High Court, the Supreme Court said that we are not allowing any active euthanasia, but yes, passive euthanasia, because right to die with dignity should be there, and that's why we are allowing passive euthanasia. But if you read the guidelines of Supreme Court, which was given in Aruna Shanbag's case, it's so huge, it's so descriptive that I don't think anyone could cross those scrutinies, because the level of scrutiny is so high that every time it will go through a board of people, board of committees, and there should be also like 2 doctors which are like their degrees should be that high, and all the scrutinies are given. If you are interested, you can read that, what is the decision, what are the guidelines of Supreme Court on passive euthanasia. So even now, if you want to see the present condition of India, active euthanasia is not allowed, but passive is allowed only on the patients who are in complete vegetative state. They have been comatized and there is no hope of life or no hope of any medication that will be useful, that will prove useful on them in the long term, and then only the euthanasia will be decided. So do you remember the Munna Bhai MBBS movie? Have you seen it, or it's too old for you?
Ma'am, I have 2 questions, ma'am.
Yeah.
Ma'am, one, in the suicide thing you told, ma'am, that attempt to suicide is an offense, and now it is struck down by the government because it is unlawful. But if a person encourages another...
It hasn't been struck down yet.
Okay.
It hasn't been struck down because...
unlawful, right?
Yeah, it is unlawful.
So if any other person encourages a person who is frustrated, then that person who encourages is punishable, right? It comes under section 305.
Yes, so we have 305 and 306. 305 talks about 3 classes of people. If the person is child, okay, or if the person is insane, he's mad, he cannot think properly, or if the person is intoxicated, who has been given so much alcohol at that time and then he was abetted as in instigated to commit suicide, then that time it is punishable, okay. This was 305, and even like 306 says that no need of child, you are, even if you are major and you have a sound mind person, but if still someone is instigating you to commit suicide, then that person will also be punishable, okay. But suicide hasn't been struck down, suicide is still there. 309, it is still there, it hasn't been struck down, though it was said that a right to life does not include right to death, okay.
Ma'am, so you told that about Aruna Shanba case. That rapist was not arrested, ma'am.
Rapist was arrested, but he was not arrested under the rape. Okay, and you know that rape punishment is higher than the unnatural offenses. So that time, because we are talking way back, right, that time rape was only included when the vaginal penetration is there, and that time it was anal penetration, and that's why it was covered under unnatural offenses. And if you see the unnatural offenses punishment, it is much lesser than the rape punishment.
So it was not covered under 375.
No.
Okay.
Any other question?
Ma'am,
Yeah.
you said that active euthanasia is something, ma'am, okay, active euthanasia, as I read it, it mentioned something about only related to incurably ill or terminally ill patients.
Yes, only terminably, like if a person is very ill, then only we will be allowing passive euthanasia, and the guidelines are like, as I said, very difficult. But active is not allowed. So if you are a major, you can do something, or just because or you are frustrated, you cannot take the life. So you cannot. So that will be active euthanasia, which is not allowed.
Ma'am, like, can a patient go outside of India and take an attempt at active euthanasia?
See, if at all he is a Indian person and he is even going into the territory of other person, still he will be tried under IPC. He can be tried under IPC. So if that person is tried under IPC, where 309 is a crime, and then he cannot even say that, because active euthanasia is not allowed. So even if Indian person is going on the territory of some other territory of any other country, still he will be tried under IPC because he is basically an Indian person.
Also, ma'am, for yesterday's class, we had looked up the Aruna Shanba case, and when I was reading that, I came across the Article 309 as well. And it said that the government had decriminalized it back in 2014 itself.
Which one?
The attempt to suicide, Section 309 IPC.
No, it is still very much in this thing. They said that it is like, earlier cases said that you have to strike it down, but as per my information, it hasn't been taken out. Can you give me that case law or whatever the source of your reading? I will read it again.
Oh, ma'am, I am reading it out of the Wikipedia page. So it says that, ma'am, or else I'll just do a thing. I'll share the link with you.
Yeah, okay. And Wikipedia is not an authentic source for your information.
Ma'am, not only Wikipedia. Like when I Google Section 309 of IPC, it gives the 2014 judgment saying that it has been struck down.
There was the thing that it should be struck down, but with my information it hasn't been. But okay, I'll just read it again. You just send the link to me, okay, and I'll read it again, and we can have a discussion in next class then.
Okay, ma'am. Also, I had a doubt regarding the Article 19A, freedom of speech and expression. So this
Okay.
is in connection with contempt of court. So does contempt of court also include like social media websites or newspapers, etc.?
Yes. So no, actually contempt of court is different. Okay. So contempt of court, because judiciary is the highest authority. Okay. And that's why we treat judiciary as God, right? Because their decision is final. And that's why it is like one institute where we shouldn't be doing any insult to judiciary. So contempt of court is one of the ground which is different from this, because we discussed this under sedition, right? So which is also applicable ki you shouldn't be it is applicable only till when you are not instigating the people to do any violence. But anything that you are writing, anything, even how much aggravated form it is, but if it is not aggravating people to come and to take weapons, then till then that point of time it is fine.
Ma'am, what is the line that separates contempt of court and a constructive criticism or giving your opinion?
Um What is that line? Actually, that line it's not described anywhere as such, but they just say that, the court
Actually,
should feel. Yeah, Darshan, you have anything to add?
you can see the details under Contempt of Codes Act 1971.
Okay.
Ma'am,
So, yeah.
like right now there's some case going on, the Prashant Bhushan case. The content.
Yes, ma'am. Even my question was deleted. Like I was building up to that itself.
Prashant Bhushan's case.
So
Yeah,
he didn't
that's right.
incite any violence. I don't think he incited any violence.
Mm-hmm.
But yeah, so apparently he wrote something in a magazine back in 2009, and now he's been is the like the charge for contempt of court. Yeah, so
Mm-hmm.
like uh, the someone else said that they asked that what's the where do you draw the line between contempt of court and constructive criticism?
Okay. So, was it given by himself? Like, okay, this is what I said, and this is what is written on the books that, and whatever I did hasn't ignited people to do any crime or any offense for that matter.
Ma'am,
So,
more
what
than
happened to that?
offense, ma'am, they're more targeting they're citing his tweets against the CJIs as the reason for this contempt of court accusation.
Okay. And we have discussed this, even when I was teaching, that contempt of court or like sedition, even for that matter, it has been misused to an extent. And that's why the Law Commission also said that we should take it out. Because when we have the Supreme Court's decision only, where Supreme Court has clearly said that you can talk anything unless you are not igniting or not attracting any offense, or you're not saying anyone to, if there are no one is getting affected with what you have said, or in violence as in to do any offense, till then it is fine. So we should be going with the Supreme Court decision, because that is final, right? And if we talk about the contempt of court, yes, that there is a separate law which says that okay, these are the things which will include in contempt of court. And I haven't gone through that act at all, because there was no need of me going through that. But if you want to just see it, just go through it once. If you don't understand anything, just let me know, then I can also read, and I can help you with it.
Okay, ma'am.
Yeah. Okay, then I'll just wind up today's class. Read about Aruna Shanba's case, read about all the freedoms that we have discussed, read about Menaka Gandhi case, A.K. Gopalan case. I will take it again because it came under the Preventive Detention Act, and he raised this concern that, my freedoms are violated, my rights are violated, which are given in 14, 19, and 20 as well, with along with 21. So 20 we have to see that what is given in 20. Okay, so next class I will be teaching you 20, article 20, and we'll see how much we can cover, and that time we'll again discuss the A.K. Gopalan case.
Ma'am, excuse me,
Okay.
ma'am.
Yeah.
Ma'am, I have no doubt. I wanted to ask that you're going to give any questions, legal questions of previous years and all.
Yes, so I was planning that once the 21, like all the freedoms, not all, the 21 and 20 also is once finished. So that time I will give you some passages. So we will work on passages before going to right to freedom, right to religion and all. But most of the passages, they are covering 14, 19, 21. So you need to understand all this. That's why I'm teaching first till 21. And once the 21 is finished, then we will go to the passages.
Yeah, we should be thorough in all this, then we can answer.
Yes. Okay.
Thank you. Thank you.
Okay, guys. Chalo then. Bye-bye. Take care.
Thank you.
Thank you,
Bye,
ma'am.
ma'am.
Thank you, ma'am.
Bye.
Thank you, ma'am.